We can start with the recording and live, it says.
Yes, I think they're starting. Katyayani, is it started like the live stream? Just
It's
We can start
it's
with the
just
recording and
processing. You can start with the recording.
live,
The
it
live
says.
stream is just
yes, I think they're starting. Katyayani, is it
Recording.
yeah, I can. Okay,
it's
Live stream and you can record.
yes, I'll do that.
Both can happen simultaneously.
Yes,
I think so.
yes. It seems like it can. You have to approve, but as host.
Host is approved. You have to
Yes.
record to your computer.
Hi. Yes, sorry guys. There was some feedback, so the live stream has started. The video is also getting recorded, so please carry on.
Okay,
Okay,
great.
great.
Okay, so thank you everyone, those who have joined, and we are hopeful more people will join in soon. So the reason we are organizing this webinar today is because in the year 2023, we had the Digital Personal Data Protection Act being passed by Parliament. The act hasn't been enforced yet because the rules haven't come into existence. And in the year in the year and a half following the act, there were a lot of conversations around the rules. And there were a lot of media reports also with the government doing a lot of closed door consultations, mostly with the industry. And so civil society was not involved in the process at all in sort of framing the rules, and every once in a while there were leaks, media leaks about the rules coming out soon. But finally, it was only in January of 2025, almost 16 months after the act was passed, that the government finally released the draft rules. So what we have now seen with the draft rules, and I think some of our concerns that we had with the Data Protection Act, chief of them being that I mean, the name of the act is data protection, but what it does end up doing is enabling state surveillance and corporate capture of data. um, and it sort of also, while it does, I mean, if we were to compare a scenario where there is no data protection law in existence to the fact that now there is one with some framework which does provide for a notice and consent framework, which does lay down what are the rights of people with respect to their own personal data. So there is some progress, but at the same time, we also regressed a bit when it comes to the right to privacy, the right to information, the right to sort of seek accountability from the government, the right to welfare. So there were, like, we went one step further and two step back with the act. Also, the act, when it came to Parliament, it came at a time when there was a lot of protest and turmoil going on in Parliament. So we actually did not see a comprehensive debate happening in Parliament, because the in both the houses of Parliament, the act was passed amid protest and chaos, and opposition MPs were not able to participate in the debate on the bill, on the personal data protection bill. It was mostly the government and the MPs from the BJP who spoke on the bill. So we also did not see a critical debate happen on the act in the Parliament. And of course, since then also, even in within the civil society space and within media, we haven't seen a lot of critical debate happening on the act. At that time, the most the conversations were basically centered towards when the rules will come out and what the rules will provide. And now that finally the rules have come out, we see that a lot of things that we were disappointed with the act continue to persist with the rules as well. The rules, to a great extent, do not clarify or do not sort of give us more understanding of how some of the gaps which the act had, sort of left unaddressed, how might they be addressed by the rules. So there are still a lot of open questions. There are some things that the government has tried to bring in through backdoor of the rules, which were not mentioned there in the act. So for instance, one area of concern that has emerged is this government's push to bring some kind of a mechanism to verify identity of people using the internet, particularly social media websites, in the name of protecting the rights of children. So there they are saying that for children to be able to access internet, and for for companies who are offering any kind of services on the internet, for them to be able to process the data of a child, if the child is a consumer of their services, they need to verify consent of their parents, and for that they need to verify the identity of the parent. And so it sort of seems like a way through which the government wants to bring a KYC kind of a mechanism for people to use social media. And that is something that we find very problematic, because it could in effect kill anonymity online completely. So there are, these kind of things that we are concerned about, that the rules try to do, which according to us, and I think we have lawyers who have joined us today to speak, might be able to throw more light on. But these are the kind of things where we think that there is a certain overreach that is happening. The act had laid down a framework, and the rules were only expected to provide mechanism to operationalize that framework. But what we see is that the rules, which are essentially subordinate legislation, they are essentially rules which have been drafted by the government and not passed by parliament. They are trying to supplement and supplant things which are not there in the act. So these are some of the concerns that we have with the act, and which continue to persist with the rules. And so we'll do a deep dive in this webinar on some of those concerns. And the idea basically is that right now, since the government has invited comments on the rules, and the window to give your comments to the government is open till 5th of March. So we have another week or so. So the hope is that all those who have joined this webinar and all those who will watch this video later will be able to form a considered opinion on the rules, and will be able to participate in the ongoing consultation process and share their critical reflections on the rules with the government, so that it could inform the ultimate rule making process, and could inform the ultimate shape that the rules take. So with that, I will hand over to Mridula to carry forward the conversation. Thank you.
Hi, everyone. So I'll be moderating this conversation with Prasanna and Indira. And we'll start with some questions for Prasanna first. What are the concerning aspects of these rules which is not apparent, and they are like indirectly trying to have certain agendas which is probably not apparent, and how do you see that, Prasanna? Prasanna, you're on mute.
I see this rule as an exercise, as a continuum from what has evolved as trying to get the data protection legislation in place in India, right? And that evolution must be put sort of on the record as to how did this begin. So the first sort of green shoots of this history of trying to get a data protection legislation in place was during the Aadhaar litigation, right? In fact, the government tried to adjourn those hearings on the ground that they had now constituted a committee under Justice Sri Krishna, who is former Supreme Court judge, and that they are looking at putting in place a comprehensive data protection legislation, and therefore the Supreme Court need not venture into the aspect of whether Aadhaar violates privacy or does not violate privacy, and that any data protection legislation that it's put in place, Aadhaar will comply with it. Right? That's one technique that they used back in 2017. And in fact, that committee was formed then. But the Supreme Court anyway went ahead with its hearings, and then we had the right to privacy case in 2017, and then the Aadhaar judgment in 2018. But immediately after the Aadhaar judgment came out, the Justice Sri Krishna committee also came out with its report. And then there was another draft in 2019 and then another one in 2021, if I remember correctly. Whether that was published, I don't recall, but certainly it was readily available to all those people who were asked for. And then we are left with the one in 2023. If one traces that history, even though the context for the need for data protection legislation in India was felt in the context of the government or a government instrumentality violating citizens' privacy, that was the NAJAR program. So the 2018 draft was about balancing the right to privacy with India's economic interests, and also interests of innovators and startups and digital economy. Right. By 2019, so what started ideally as an effort to protect people's privacy became protect business, and then by 2019 it was about protecting government. Right? Or the 2019 draft was about exempting as much of governmental functions from the purview of the Act. All that. So, but by the time it came up to 2023 draft, it did not just sort of saving the government. It is now about enabling the government to satiate its never-ending hunger and appetite for data from its citizens. And that is why you had the government and government functionality, government instrumentalities do not have, they are all there's a blanket exemption from most of government activity under section 34, 36. In addition, they also now enable the central government to be able to collect any data that it pleases, even if it is not enabled under any other legislation. Now this is like the data legislation. This is now giving a blanket general purpose authority for central government to at its beck and call all personal data collected by anybody, right? Because anybody who has even minimal functional data is a data fiduciary, and under section 36 now which is implemented as Rule 22, central government now has powers to then at its beck and call any person to turn over whatever information that it had. So is this such a big problem? It's government. It's a democratically elected government, right? So they want this kind of information about. They have other legitimate government functions to perform. This is such a big problem. So the question there. So to answer that, I would try and kind of place in contrast what happened under the CRPC, even under the colonial rule. Right? Now later it became the 1973 CRPC, which kind of borrowed from the 1898 CRPC. That is to say, even when an offence has been committed and a commission of an offence is being inquired into by the police, of course they have the powers of production of documents or requiring any person to produce documents, all of that. But when it comes to a third party, so for example, when there is a postal authority or a telegraph authority which they have to summon to turn in a document which is a private communication from one party to another, that they could not do it without a judicial warrant. That is when the purpose is defined, where there is an offense that has taken place or that is alleged to have taken place, and in furtherance of that, there's an inquiry proceeding, some kind of investigation on. There, the police could not still procure that information from a third party, particularly if it relates to private communication. It had to have a judicial warrant. From there, where in fact there was very minimal data that is being, very information, it's just a private, maybe an inland cover or a telegram being sent. Right here, every data fiduciary here will have terabytes, gigabytes and terabytes of personal data of all users that they collect. And to kind of confer and give that kind of awesome power to the central government, is that something that was that in consonance with the promise and the undertaking that they gave to the Supreme Court? That's one question. And two, is that at all in the interest of us as citizens to give to the central government that kind of powers? And those are questions that we must reflect on. Right? The answer in my mind is clear, but it is also, but in fact, the question itself kind of in many ways sort of encompasses that answer. I leave it at that. There are several other issues, including consent managers and persons with disabilities and children, all of that. I think we'll cover that over the next few more minutes. But for my opening remarks, I leave it at here.
Sure. Thanks for that, Prasanna. Just very quickly, sort of like a follow-up on that point, because you brought up a very interesting point about some kind of judicial application of mind, when it came to, for instance, interception orders, etc. But now what we see, as you very clearly mentioned, that it seems like a sort of like a general purpose authority, the term that you mentioned, that has been given to the government to sort of demand for data from any data fiduciary. So one, is there a possibility to remedy this situation by bringing in this aspect of getting some kind of a warrant from a judge before this order is issued by the government to a data fiduciary to give any data that is under their control? Would that remedy the situation, or is there no possibility of any kind of remedy in this situation, and the only way to sort of make sure that the act and the rules comply with the idea of data protection is to sort of just do away with it completely?
Right. So there should certainly, a warrant would mean that you'll have to impress upon the court the need for that kind of data. When that need, then there is obviously, you need to specify what purpose it is. And what are those, the purposes for which you can ask this kind of personal data? That will have to be legislated, and it has to come from a plenary legislation. That has to be determined by Parliament as to what purposes are correct. If it is in furtherance of an investigation of an ongoing investigation, there is already powers under the CRPC to ask for and obtain production warrants. Right. So therefore, whatever legislation that deals with those specific purposes definitely have those kind of warrant provisions and how that kind of information can be obtained. Here, what it does is that even if there is no such law, this gives a blank check. If you are a central government, you have authorized some person, and he just recites as a mantra that it is required under this act and under Rule 22, read with Schedule 7. I ask this information, and the data fiduciary would be under an obligation to turn in that information. If they do not turn in that information, they will be liable to punishment under the Act, and it can even extend to imprisonment if I'm not wrong.
I have one more question to that, Prasanna. You mentioned like all of this is, of course, under the Rule 22 of the rules, right?
Right.
So do you feel, or do you think that the Rule 22 could sort of be ultra vires of the Act in some way? Because if you see Rule 36 itself, it does not seem as apparently problematic. It's vague in all of that, yes. But this Rule 22 goes a step further to like go beyond the Act itself. Is that something that is to be concerned about as well?
Right. So certainly there is an element of that going further away from the Act, but honestly, Section 36 of the Act isn't a particularly glorious provision to start with, right? Even that is fairly broad, right? You see, central government may, for the purposes of this Act, require the board or any data fiduciary or intermediary to furnish such information as it may call for. Right? There are no guardrails at all that circumscribes this power under 36. Right? 36 is clearly a surveillance power. Right? That we do not have guardrails at all for that. Nothing, no guidelines that will kind of circumscribe the the exercise of this power makes even Section 36 sort of ultra vires. It's excessive delegation. Right, but that's, yeah, I mean, whether 22 is even violative of 36, perhaps those are alternate arguments that we can place in court.
Thank you, Prasanna. My next question would be regarding, okay, the government is obviously protecting itself and enabling itself to do more with this framework. But what about its friends in the industry? Like, for example, one more concerning provision is this consent management scheme. Of course, this has also been kind of recommended by the B.N. Sri Krishna committee in its report as well, because they wanted to avoid consent fatigue and all of that. But the way it has been formulated under these rules seems concerning as well. What are your thoughts on that?
Honestly, the way in which consent manager would work, right? So it is a third-party provider who would manage consent. We've not had great success with trying to get these kind of third-party managers in other regulatory laws to be as transparent and rights-respecting as they should be, right? But I think that is a kind of larger cross-cutting issue than an issue with the rules itself here. I'll give you an instance. We have Sybil, right? Their practices and the way in which they collect data and then score us. So that's still proprietary, and there isn't a lot of information that, to the best of my knowledge, they're not transparent enough, and there is therefore a lot of litigation on that. So this kind of third-party management of what are essentially user rights, we've not had great success, and nothing in the rules kind of departs from the standards from how we are known to have those third-party managers operate. That gives me any heart there. But that is, as I said, it's a cross-cutting issue. I'm not so sure if it's particularly only problematic here. But if Indra and others have another view on it,
Thank you, Prasanna. And I also want you to like shed some light on the board and its lack of independence. One thing we observed in these rules is that the board is predominantly represented by the executive.
Right.
Like for example, there is no need within these rules or the law itself
right.
to include any member from the judiciary or have that judicial application, like Mansi pointed out, and you had as well, like with the CRPC, a court or the a judicial body has to intervene and give permission. But here, the executive is completely doing away, and the board, being an adjudicatory authority,
Right. Right. It has a number of adjudication functions. Here, interestingly, the board is both prescriptive, right? So it has powers under the law to prescribe several guidelines and standards, all of that. But it also has adjudicatory functions, right? But there was certainly a model that could have been looked at where the adjudication functions are entrusted to another body, a body that is more independent, that has judicial members and people who had served in the judiciary, or people with trained in judicial application of mind. So certainly that is a major concern, right? And also because data protection is for India, certainly it is kind of a nascent function. It needs to be evolved, and some of those principles that we evolve have to be in consonance with the kind of judicial trends that we are used to. And the board being packed with executives, very likely retired joint secretaries, people who treat it as sinecures, is perhaps not the way to go. And that also raises concerns that we have with some of the other regulators. Right? So regulatory capture, where political appointees are kind of used, and then revolving doors from the industry to the board. So all of those, there are no safeguards at all in trying to secure the independence of the board, not just from the government, but also from the industry.
What could some such safeguards be? One question, and a follow-up to that would be, would, like, for example, periodic reviews, like there are compliance costs as well that this industry and the industry and even the government is using. Like, we are trying to reduce the cost of compliance is what one argument they kind of use. So of course, at the risk of our rights, but they are kind of making a cost benefit analysis there, I guess. So what would these safeguards be, and how, whether they are going to be they inexpensive, or whether they will increase the cost of using the internet itself, is another question we had.
Well, see, that second order consequences of a data protection legislation like this and the rules coming into force, and data fiduciaries having to comply with these provisions. So that is, you see, it's going to be a little difficult for us to either forecast or to even say whether there's going to be any significance at all, right? But if there is an analysis on a cost benefit analysis and what is the cost of compliance, etc., it will importantly need to factor in the fact that we did not have any data protection legislation. India was one of the few major countries that did not have a data protection legislation in force for at least 7 years now. Since 2017 was the first undertaking was Supreme Court. We've not had one in force for 8 years. So this kind of user cost for non-compliance, or the benefit that the companies reaped for not having to comply with any data protection legislation, will also need to be factored in. Right. So therefore, so this cost of compliance, because given that anyway the cost of compliance is the same across the industry, across all the players in the industry, and therefore it's a bit of a it's a level playing field. If that is the case, businesses ideally need to have no complaint about. Other than other issues that we've highlighted here, but generally the cost of compliance alone is something that I do not believe is valid criticism of either this bill or any bill.
Okay. Thank you, Prasanna. We'll come back to you and we'll ask Indra. We have some questions for you as a human rights advocate who's practicing and like enforcing human rights in courts of law. What are the implications of these rules, or the act also in general, on the civil society's work in upholding human rights? Is one question that we have for you.
Sure. So, yeah, thanks for organizing this discussion, and for me all of us being a part of it. But as was being discussed, this act and the law and the rules, which actually form a vehicle to now operationalize the act as and when the government pleases, this set of rules and the act actually, in my view, they legitimize the illegitimate in a sense, because what is happening is that on the one hand, the nomenclature is that of data privacy, where there seems to be a great emphasis on the rights of the individual to protect privacy, as has been protected by Puttaswamy and so on. But in fact, it allows the state to take away that right through a law. So that's very, very dangerous in my view. And it's in a very blanket way. It just says that anything for which you have not denied consent as an individual can be used if you hand your data over to private players. And apart from that, anything that the state asks for, the data fiduciary, and the term fiduciary seems to project that in a way that they will almost take care of your data, and they are meant to, but they are allowed to, and not only allowed to, but literally commanded to hand over the data to the state if so required. So that is extremely dangerous. Now, as we would be aware, the right to privacy has been recognized as a fundamental right under Article 21, under the Puttaswamy judgment. So it's the right to liberty, actually. I mean, it's recognized under the right to liberty. And so there are two aspects to it. One is one is as far as the state is concerned, and the other is as far as private bodies are concerned. And under the state, there are three sub aspects. One is to protect the individual from invasion of the state into a person's physical body. A second is the unauthorized use of personal information. That's where the right to privacy falls. And then there is the third, which is the privacy of choice or autonomy over fundamental choices, person choices. So here the state has been clearly given a carte blanche to conduct surveillance and profiling. So the danger of not having the privacy law is, of course, these two. There's the surveillance and the profiling. And then, of course, taking away or violating free speech, expression and liberty itself. And the non-state players, there's big data, there's technical and pervasive data generation, all of that. Beyond a point, you don't have a choice to remain unknown. Now, as far as human rights and civil rights organizations are concerned, I mean, do they become data principals in a sense? Do the data fiduciaries have the right to reveal whatever data? So a WhatsApp, for instance, would become a data fiduciary. So would Google, so would YouTube. So what happens? Are the data protected any longer? That's one. And does this then give the right to muzzle any dissent, to say that any questions that are asked of the government, will those then compromise the right to privacy by then allowing the government to demand the data of the data fiduciary and then target those dissenters and do more than what is being done today in a very legitimate manner. Today, even if it takes forever, there is at least the odd case where the court is actually saying that there is a violation of the rights to your work, to privacy. However, now if you legitimize that, then it becomes just that much easier and for the state to not only seek that data but just take over that data and violate privacy with impunity and violate liberty for that matter. So.
Thank you, Indra. And another follow-up to that question would be how, as human rights lawyers, can we sort of seek any remedies for this as well? Like, this is both for you and like Prasanna. Like, what are the individuals' recourse that this framework enables?
So the law has been enacted, yes, but it can't be operationalized until the rules come into force. Of course, they've also staggered the operationalization of the rules. So in my view, they really need to be challenged because they are in conflict with the Puttaswamy judgment for sure. So that's, I mean, they must be challenged, and that's one of the methods I think that lawyers, human rights activists, etc., can adopt. And I also want to just do a little follow up on the consent manager aspect. The consent manager, according to the law and the rules, is supposed to represent the data principle, that is the individual. But if they are industries, I don't know to what extent they will be able to do an unbiased job of representing the individual against the state. So I just thought I'll just add that.
Yes. Yes, Mansi.
Yeah. Sorry. So Prasanna, very quickly, Mridula also asked you to sort of comment on this point about
Right.
what
So,
remedy.
one,
Yeah,
yes.
yeah. Just before that, because Indra also brought this point up about staggered operationalization of both the act and now also the rules. So the act also enables the government to sort of notify different dates of coming into operation of different provisions of the act. So we don't know how the government is going to go ahead and do it. It's already been 1.5 years and the act hasn't come into force, which also prevents, if I'm not wrong, people from challenging the act in the court, because I believe there was a challenge, which was then the argument was that it's, sort of premature right now because the act hasn't even come into operation. So one is that the act itself, will have staggered sort of operationalization. And then the government has now enabled itself to operationalize the rules also in a staggered manner. So ultimately, when will the actual framework of data protection, of rights of individuals come into operation? We don't know. So one is, do you see that as frustrating the will of the parliament, which has, in whichever way, I mean, it was not a democratic way in which the law was passed, in which the bill was passed in parliament, but even then, whatever, even if in letter and not in spirit, it reflects the will of the elected uh, le legislature, and the government is basically frustrating it by not operationalizing the act. But at the same time, the reason that they're giving, and therefore I'm also bringing in your point of cost of compliance, the reason that is usually given is that industry particularly, they are definitely not thinking about civil society here, but industry particularly needs time to be able to comply with with the law. And the argument that they give is that even EU GDPR, for instance, there was about 2 years of time that was given for people to comply with it, etc. But at the same time, they are saying we haven't gone the EU GDPR way. We haven't prescribed something which is very, very prescriptive in nature. We have actually used very simple language. We have kept it very open. We have gone more the self-regulatory way. So on one hand, you have made compliance, but at the same time, you're using the logic of cost of compliance and difficult compliance to keep sitting on the act and the rules and not operationalizing them. So if you could also comment on this while talking about the lack, uh, presence or absence of remedy options for people. Yeah.
Right. Thanks, Mansi. I'll first take the one on remedies and on whether those remedies are actually real or illusory under the Act. Right. That's an interesting kind of way to put it that Indra did. One, certainly, even that was a criticism that we also laid at the door when the Act came, was that it had not looked at other legislations that similarly had either regulatory or those legislations that protected rights, right? Under labor laws, several cases where here the only redress that an affected user, an affected citizen can have is that he complains to the board and the board imposes penalties. There is no incentive for somebody, a user, either an affected user or even a whistleblower in some cases, be able to bring to the notice of the board and the authorities and have redress for it, and for which there is a certain incentive built in. Right? Ideally, I would say it will be a gradation. Initially, compensation only, and in some cases, compensation plus punitive damages, compensation plus punitive damages plus exemplary damages for gross violations, right? So and special damages in very rare cases, right? So all of this, so this gradation is not unknown to law. In fact, we have this in many of our laws. under the Gratuity Act, for instance, or under the Provident Fund Act, this gradation of damages being awarded, which also incentivize people to then bring it to the notice of the board, the nature of violation, the modus operandi of people who violate this law, all of that. Because there are no incentives, the board is going to be largely blindsided as to what is the modus operandi that people use to circumvent the rigors of needing to comply with the data protection legislation. Right. So that's certainly a criticism that we had at the time that the law was made, and it remains valid till today. And of course, the rules are not going to be able to address those unless the law addresses that. But that's the view that I had on the remedies under the law. The second question on this kind of ragtag sort of piecemeal operationalization of this framework. An excellent example comes to mind of late. Right? So there was one code on social security that was passed with much fanfare in 2020. That entire act is 5 years now. If I still am correct, my information is that act is not in force. The only provision that has been brought to force in that act is mandating Aadhaar to be linked to Provident Fund UAN accounts. So nothing else has been brought to force under that act. So whether this even amounts to carrying out or acting in furtherance of the parliamentary will, certainly it's an open and shut case. It certainly is not. There is. Although the parliament didn't fix a time by which the legislation had to be brought in force, but to be able to operationalize it in a piecemeal fashion, and despite every legislative measure is to address a particular societal need that has arisen at a point of time, right? So when legislation starts with the statement of objects and reasons, all of that, so that is a description of a problem that the parliament, in its wisdom, thinks exists as on that day. To not address that problem for several years, right, is certainly the government acting in contrary to the law itself. There are no two ways about it. But the fact that, yes, the parliament didn't fix a timeline makes it a tough legal argument to make. But it's certainly not something that is great for our strength as an institutional democracy, right? Where there is enough respect for Parliament's procedures, its wills, and what it has ordained. Right.
Thank you, Prasanna. And another question that comes up here is that this law has a blanket overriding effect that has been not just right to information. It's any conflict with any other law. It basically will prevail is what I think section 36. I'm not sure there is a provision for that. Now, given that there are several other laws this particular act will override, and what are the consequences of that? For example, of course, there's right to information, which is the most obvious one, but other laws being like how it might nullify the protections and safeguards under other laws.
Right. I've not particularly done a survey of what all laws it can override and what are the problems that it is going to cause. But one thing certainly that kind of sticks out as a sore thumb is this power to collect information from any data fiduciary. Right? Even if there are other, for example, the Bankers Books Regulation Act, Bankers Books Privacy Act, Financial Privacy under the Canara Bank judgment, all of that. So now they are all gone for toss. Obviously, those safeguards will. The government could argue that those safeguards no longer apply because we have now powers under this act to collect any personal information that is maintained in digital form, right? But they'll say that yes, this is only for that information that is maintained in digital form. Otherwise, we will not have jurisdiction. but that's really an excuse, that is an illusion of an excuse, because everything is in digital form now. So that's certainly a concern. Whether it will even override the protections under the CRPC, the BNSS, right? That is also a question that we may need to look at deeply, and in particular cases that arise.
And just to follow up with that, there is also like it's tried and settled law that a special act would like override and overpower general law. So my only question here is that if whether this law can be considered a special act at all, or whether it's a general law.
That is, yes, those are arguments that we may need to sort of bring to court, whether how a court will treat with it, whether what they will call as a special law, what will be general law, and also there's the rule that the later law will override the earlier law, right? So whether that rule will be applicable, I think we will need to let the judiciary evolve the principles on it. I think it's a bit early to comment on that.
If I may just add a little here,
Sure.
however, it definitely can be used because it's a later law, because it is a special law in the sense that it is to do with data protection. It can definitely be used conveniently to say that this will prevail over other laws, or even if they protect data. So that's yet another danger which is inbuilt in the law.
Right. I mean, in a sense, for example, there is a specific legislation that governs how government can procure records, financial records, from banks and financial institutions, whether it's under the Banking Companies Act, Bankers Books Regulation Act. So there are several laws there. But if there is a requirement under this act, and Section 36, read with Rule 22, is used by the authorized officer under this act from the bank, whether the bank can deny this information, citing that other legislation, I'm not so sure. We need to let that play out a little bit. Yeah, hopefully there'll be some of those banks that will take independent legal counsel and act by that, right? Yes, we also have a culture of, one of the reasons why you have all these different legislations governing different aspects of governance is that, yes, you see, when the law itself is incident on so many people, there will be all these other little pockets of power, like banking institutions, sort of being able to push back against that kind of an all-passing power. But that is a culture of compliance that we fostered, and a culture of resistance that we failed to foster, and that I'm afraid is going to hurt us even here.
Thanks, Prasanna and Indra. Indra, very quickly, I'd like you to come in, and maybe then Prasanna also, on two specific aspects. One is on the, sort of where it'll be the where it'll be the data pertaining to a child that is going to be processed, and what the government is prescribing as how that can be done, what are going to be its implication, as is very widely being interpreted. This could lead to over collection of data, because the purpose is that for you to be able to identify who is a child, and whether the person who is accessing any particular service online is a child or an adult, can only be done if you verify their age, and for that you might need to collect their some kind of government ID, etc. So one is this in effect prescribing some kind of know your customer requirements for being able to access services online, while using the excuse of sort of protecting the rights of child or even persons with disability, as is used in the rules. So one is that, what are your thoughts on this? And the second is with respect to the government exempting itself from certain following certain requirements and mandate of the law by saying that it is using this data for certain legitimate purposes, which includes provision of any kind of service or subsidy, etc. So in effect, the government is saying to trade off your right to receive some kind of welfare services from the government, which they might be entitled to under acts of parliament as well, like food security, right to employment guarantee, etc. To trade it off for your right to data protection and uh, and pri 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 pri
Also.
pri. So do you see this also as a problematic aspect? So both these questions, first, Indira, if you could come in, and then Prasanna, you could also offer your thoughts on these two aspects. Thanks.
Sure, thanks. Yes, I think it is a means to then excessively collect data on the pretext of protecting child rights. So I definitely see it as problematic, although we haven't studied, I haven't studied the child rights aspect so closely, but since they've said that they will then expect the parents to part with their own information, this is one more way of gathering more information and more data. And likewise, for the for availing of any of these uh, any subsidies or anything where the right of the consumer is also taken away, the right of the person receiving the subsidy is also taken away, and it is beyond the specific acts targeted to give specific subsidies or specific benefits to the individual. So, I would agree that it is yet another means of taking over data, and then furthermore, it also gives once the data is parted with, and that's the other scary part. It says that so long as the data is available with with the data fiduciary or the government, as the case may be, so long as it is not expressly barred in law, the data can be put to use for whatever so-called legitimate purpose that the state might consider. So it's an opening in a way to receive data relating to children, and that of course is true with also now the private sector, because there can be marketing, there can be and apart from state surveillance, because so once you get that data, it can, as I said, it can be put to use, and once the data is received even by a data fiduciary, so even if you withdraw consent as a data principle, the data fiduciary can continue to use the data for anything that is not barred in law. So now it's so sweeping and so wide. So there are various means of legitimizing collection of that data and putting it to further use, but also communicating to the general citizen of the land, that this is something that is meant to protect you and help you. So the subsidy part almost seems like, okay, we're doing something for you as a state, and likewise that you're protecting child rights. Whereas on the other hand, you're actually receiving the data, and then you can put it to use the way you deem it fit. So, yeah.
Right. Thanks, Indra. Just to come in on that, the second question on exempting government and effectively asking people to waive their right to privacy in exchange for certain subsidies from the government, right? This is the first argument that was made in the Aadhaar case, and this was an argument that was rejected by this court, right? So that is to say that you cannot have that bargain go through, right? So this is not, you cannot ask people to trade off one fundamental right for another, or one right for another, right? So that is for the both our citizens' rights. It is for citizens to assert whatever right they want to assert, and in effect, that forcing that this kind of a bargain has been St. Xavier's in a 9-judge bench decision, right? Perhaps even 11-judge bench decision, I forget. That's from then on, we've certainly had this, that there cannot be that kind of a waiver in exchange or unconstitutional conditions, right? And that view was upheld also in the other judgment, right? That effectively has been re-legislated what was struck down, right? So although in the other judgment, the Section 7 of the Other Act that said that if there are services being provided, insistence on Aadhaar number can happen, but the court went on to hold that mere insistence of Aadhaar number for the provision of services does not violate privacy, because they had struck down other offending provisions of the Aadhaar Act and read down several of the rules under the Aadhaar Act, right? But now data protection is a legislation that recognizes that there is now widespread abuse of people's privacy. This is a legislative measure to curb that abuse and to secure people's right to privacy. In that, if you are exempting and giving a carte blanche for all government activities, and particularly government activities merely because they provide subsidies and services and welfare benefits to people, that first of all is in violation of the Supreme Court judgment, and two, it does not stand up to any kind of modern standard legal scrutiny on balancing fundamental rights and the bargaining for one fundamental right over another. That's your second question. The earlier question on children and the extensive data collection in order to comply with these directives for the protection of children, and purportedly for the protection of children and for the protection of persons with disabilities. See, this certainly is a little bit of a problematic. A solution to this, to how much data that you can collect in order to ascertain whether somebody is a child and whether a certain service to be made available to that child. So this is very much an exercise that needs to be undertaken after several scientific studies, right? Because there are dangers both with this overcollection and undercollection, right? So we need to recognize that. So in what cases is the danger of overcollection worse than the danger of undercollection, and in what cases it is the other way around? So this is something that one will need to make a legislative choice based on studies, some kind of evidence to back it. But I don't think we've been provided that evidence, and our own instincts have been now that overcollection, where you are enabling several data fiduciaries and significant data fiduciaries to have a fairly cleaned up database of all the children that are using their service, right? Which is more of a honeypot for people who are looking to exploit that kind of a database. So this kind of cost benefit analysis, I'm afraid, has not been done, and even if it has been done, it has not been disclosed, and therefore the legislative choice for that is without substantiation.
Just want to add a little to that. Fundamental right is guaranteed and also cannot be given up, and that's also settled law. So the right to privacy recognized under liberty, there's no question of bargaining or even giving it up. That's one. And if it can only be tempered, if at all, with it has to be reasonable, and it has to be based on a law, and this is the so-called law, that instrument, but it's just stripping it away. So yeah, just thought I'll add that. Thanks.
Thank you. I just want to add, like, or I have a follow-up comment slash question there. Now, children's data being like discussed extensively about. There's one thing I noticed, for example, targeted advertisements at children. Now they're collecting this much data of children without their, them really realizing or being aware of it, and in the name of protecting children, of course. But there's also this exemption. The law provides for, like, some safeguard against like tracking, monitoring, and targeted advertisement, but the rules seems to nullify that in effect, in one of its schedules, I think. Like, and it also is very vague because it kind of limits the purpose and nullifies it to three, I think, classes of entities. Like, yeah, educational institutions, mental health professionals, and healthcare professionals. Three entities, three classes of entities. And if you see what educational institution is, it's very broad. Any institution that provides for an education is very, very broad. It basically could include even like edtech companies and other things. So, and I was just thinking like what the impact of this would be. And like whether children's interests in the name of being like protected, like I feel like they're also being sold on the side to certain types of entities. I don't know, like especially health and education. Yeah. So any observations or thoughts on that?
No, I leave it to Indira to for that, but I certainly agree that yes, that kind of again another blank check to education companies, healthcare, to do whatever they want with that data. Right? It certainly sticks out a bit.
Yeah, I would concur because children offer a huge market, and so with this kind of they'll be able to analyze it and do anything, as I said, which is not barred in law. So that's a huge danger, and definitely it's just literally handing over the data in a carte blanche to large organizations to be able to do as they please.
And to also add, so
And this
what does this blank check
and
mean? Right? So this blank check means not only that the exemption from the act, any of the, so it is not about needing to give notice for collection. It is also about further disclosure, right? So it is and further disclosure for a fee, right? If for example, as government as a healthcare provider has certain information inoculation charts of all children under that particular primary health center. See, that database gets being sold for a fee to other third-party brokers. So this is not a concern that we have that is that's completely out of the world or outside from another planet. The 2019 or the 2020 economic survey made this as a pitch to say to commend the Ministry of Transport for having monetized its Vahan database by selling the database to other interested third parties. And the economic survey said this is the way to go. These are resources under the control of the government. Government should be able to find ways, creative ways, like what Vahan, the Transport Ministry, has done to monetize that data. And imagine that Ministry of Child Protection and Health and Family Welfare going that route and trying to monetize that data. That is exactly the kind of behavior that a data protection legislation must contain and prevent. But that is the exact kind of behavior and conduct that this data protection legislation and the rules that have been framed enable. Right? That's yeah. I don't know how else or how better to articulate that identity. So it's a bit of a joke.
Just to sort of
and
like
and
contextualize that through an example, there were, if I'm not wrong, certain petitions which were filed against the installation of CCTV cameras in schools. I think it was tried in some government schools. So now, if you go by this, what they are exempting all educational institutions. So I think this sort of like legitimize that kind of intervention, right? So now you can go ahead and use CCTVs in schools by saying that it's for the purpose of tracking and ensuring safety, etc. So
yes.
Yeah, sorry, Indra, you were saying.
And
Yeah.
and one more thing, what about influencing the young impressionable minds of children? You know, to influence them to think of the government in a particular way. There's so much that is possible, that this is the sovereign role of the government. So these are some of the other things. It's not barred in law, so there is that part as well, apart from monetizing the data and selling it to monetary organizations. I mean, to the corporate world. Yeah.
Thanks, Indra. So we are also now opening up the floor for questions, and I think Masood had already mentioned one question in the chat and another comment also he has. Masood, would you like to come in and speak up and also ask your question and share your thoughts and observations as well?
Yeah, hi. So, yes, just wanted to understand about the categories defined by the DPDP Act and the rules. Because to build an argument about safeguarding of information from private entities or government entities, so there should be clear definition of what kind of information should be protected from misuse by the private or government entities. So, for the purpose, I wanted to understand, is there any clear definition provided in the DPDP Act or rules about the personal information and sensitive personal information or data? Because I have read the Sri Krishna Committee and the IT rules. So, they have defined very vague parameter like password, financial transactions, metadata kind of things. So, for example, in Telangana High Court have published complete details of petitioners in public domain on their website, like my Aadhaar number, my PAN card number, my bank details, my name, my address, my mobile number. So I wrote them. This is my sensitive personal data. So they have deleted. So there is a clear need to argue about this kind of definition from the state, so we can advocate for the protection of our personal data, sensitive personal data. So in this context, I wanted to understand what is your opinion personally.
So this question of, see, the Data Protection Act 2023 has done away with this class of personal data being either sensitive, not sensitive, etc. It has recognized that that personal data, the sensitivity associated with any personal data could vary, and it falls in a different kind of spectrum. It recognizes that, and it has done away with the classification that you mentioned, which was under the IT rules, right, where sensitive personal data was specifically biometrics, passwords, financial information, all of that. So that, at least that, and it is now recognized as a spectrum. It's true, it doesn't define what it means, what the personal data means, but I don't think that's such a bad thing, right? It's a standard that will evolve, right? It has defined personal data to be personally identifiable of any individual, whether living or dead, and that is also consistent with some of the other data protection legislation, right? So this doing away with the gradation is not particularly bad thing, and we can potentially look at that evolving as a standard over time.
Thank you. And a quick comment with response to what Mr. Prasanna said about monetizing the data, public data. So yes, the Abha ecosystem we have seen how the health record created by the government platform are shared with the different private entities. So
yes, can you elaborate on that a little?
Yeah, Abha program was launched by the government of India a few years back by saying we will provide free services in the government hospital. So they ask people to enroll for that. So similarly, we have a scheme in the state like Arogya Shriya, where government provide free treatment to the people in the hospitals. But in Abha, now they are issuing Abha ID and Abha ID card to the people, saying your health record will be stored in your ID, So the same database will be accessible to the ABHA ecosystem, where private hospitals, private agencies working on the health sector will have access to this database. Insurance companies, private hospitals, all this. Ayushman Bharat, yes.
Yes, thanks for making that point, Masood. And that actually also got me thinking about this one more point, which, through which the government, and this is there in the act itself, where they basically say that if any database is already available with some state, and they actually use the word instrumentality of the state, and I'm not sure how much clarity we have on what all would be included in an instrumentality of state, but the basically state enables itself to sort of share this data, even if it is collected by one state entity. It can be used without seeking consent of people who had given their data to one entity, and it can be used by other entities as well. So I think so when you were making your point about that, once data has been given for preparation of any kind of health ID, and for then it to become available to be processed by other, not just government departments, but you've said private entities as well. So I think also something to be concerned about. But we are, sort of towards the end of the webinar. And I think, there are no more questions either on the chat from the participants, or we have also sort of the questions that we had planned for this session we have asked. So very quickly, I would invite both Indira and Prasanna to share their closing comments with just one, and sort of like leaving with just this one thought, again, reiterating the fact that the government has invited comments on the rules till 5th of March. As of now, it was originally 18th of Feb, though, so the deadline has been extended once. So as of now, it stands at 5th of March. And for anyone who is interested in giving their comments on the rules, has to go and create an account on MyGov if you already don't have it. And it only allows you to make your submissions in specific formats. So for each rule, it allows you to type out a 2500 character response. So actually, so initially we were thinking that we'll create a common sort of document and seek endorsements on it, but that cannot happen now because there is no email ID to which we can send that document. We can only give some submissions within that, restricted space. But what we can do is, what we are hoping to do is that once our sort of the submission that we are working on, NAJAR and Article 21 Trust. So we have sort of like, we did some sessions together. We have prepared a submission which we are hoping to finalize in the next few days. And we will sort of share it with others who are interested in adopting it. So you can use it, you can add your own stuff, you can add your own points and observations and insights to it, and then share your inputs on the MyGov portal. So as Mridula and I were discussing, it's quite ironical that, sort of there is data protection happening in the process of giving your consultation, giving your response to
violation is happening.
violation. Yeah, violation is happening because we are being forced to part with our data to participate in the consultation process. So yeah, so but encouraging everyone to sort of share their responses by 5th of March, and with that, inviting Prasanna and Indra to sort of share their closing comments, and then we'll close the webinar.
Thank you very much, Mansi and Mridula, for putting this together and having us speak on this, and also think about and reflect on a lot of these issues, which are generally in our back of our minds, right? So in fact, I mean, writing on it has also become kind of sparse, right? Part of the reason is that that kind of a vibrant dialogue between the government and the policy makers and those have something to say on the policy has been reduced to this kind of a mockery of a consultation where each rule you only need to get to 2,500. There isn't a rich dialogue that is now possible between the government and civil society, right? So thanks much for organizing this and helping us get our thoughts together and try and think about some of these issues. Yes, and I also join them in encouraging everybody to write in their comments. Right, so even though this consultation, in our view, is not an effective one, but it is still a responsibility that we must discharge and try and try and give our comments that we have on rules. Thank you very much.
Yeah, thank you, Mridula, Manasi, Prasanna, and everybody for joining today. It's been very enriching to have worked on this together. We've had a few sessions, so we've discussed various aspects of these rules. We've tried to see how we can also question so that there is some enabling of reflection on the part of the government. Questioned so that we can also question the law in a sense, although I know that we have the chance to give our feedback on the rules only, but given that the law itself has not been operationalized, we are trying to do what we can. As I said, it's also a bit of a dangerous situation where there's been an attempt to normalize the several violations of what ought to be the zealous protection of data privacy, but we are trying to do our bit. And yeah, I was not aware that we could only put in those 2,500 words. We thought that we may prepare a nice document, and like in the past we've sent to a particular email ID, but if that is also not possible, then that becomes a bit of a thing. But nonetheless, we'll all do our bit to try and contribute to whatever changes we can try to make. So thank you all for joining, and thank you for your remarks and for your presence and participation.
Thank you, Indra, and thank you, Prasanna, for joining us today. We'll wrap this up now. Thank you so much.
Thank you. Thank you, everyone.
Thank you. Thank you. Bye-bye.
Katya, I
Thank
need
you.
to stop the live streaming.
Okay, thank you.
Okay.
Bye.
Just